Morning. Long time no see. Everybody's all rested. I'll go ahead and call the meeting to order. Dana, would you please do the roll call?
Yes, Councilmember Hoffman?
Yes.
Councilmember Bash?
Kevin?
Councilmember Bash? You here? He was just talking to us. Hear us, Kevin? Oh, yeah. Let me turn this up. Go ahead.
Yes.
Okay, now we got it.
Got it. Great, thanks.
Okay.
I'm sorry, everybody.
Nope, we're good. Councilmember Alleman?
Yes.
Mayor Pro Tem Grummeyer?
Yes.
Mayor Newton?
Here. Good job, Dana.
We did it today. All present, thank you.
Dana, do we have any public comments?
I have no public comment cards.
Thank you. We'll go ahead and move into public hearings. Item 2A, hearing on Luke Matson's grievance appeal. Andy? Okay.
Yeah, this is pretty straightforward. This is, as you're aware, that this is an appeal of a grievance which was denied at the city manager level to the personnel committee. The grievance was filed by employee Luke Matson. It concerns principally whether or not he's entitled to time served credit toward vacation accrual after a break in service. But that's what the hearing will be about. The process this morning will be a 10-minute opening statement by each party, beginning with the grievant. There's obviously, that's the maximum, not the required. And followed by each party presenting their case. Each party has a maximum of 1 hour. Again, that's not the required time, that's the maximum time, followed by closing statements. After the conclusion of the hearing, the council will recess into closed session and discuss what their conclusion is, and we provide the city and the grievant written decision within 10 days of the hearing. So I guess we're ready to begin. So
Morning, everyone.
Good morning.
Hope you had a good 4th. We did. It was the first year that he didn't work, and our kids were home in 6 years together. They're both military, if you haven't already known. We have a son who is Air Force, and we have a daughter who is Navy, so it was great having them home for the holiday. So first off, I'd like to thank everyone for taking the time to be here today. My name is Lacey Matson. I'm the lead speaker and consultant for Local 606, which is formerly known as the Public Works and Parks Maintenance Workers Association. I have been asked by Local 606 to be here today to represent Luke Matson, who is a sewer collection technician 2 with the City of Norco. Mr. Matson holds the highest sewer collection certification, grade 4, with California Water Environment Association. He holds both a water treatment and a water distribution grade 2 certification with the California State Water Resources Control Board. He also holds a backflow prevention assembly tester certification with California and Nevada American Water Works Association. Mr. Matson has over 25 years of experience in the water and sewer industry, both in the private and public sector, with over 10 of those years, or we could say over 19,000 hours of service with the City of Norco. On March 30th, 2022, Mr. Matson emailed a grievance about vacation accrual to Human Resource Manager Cindy Balderas. Prior to the formal email being sent, Mr. Matson talked with Derek Lacombe, his superintendent, and was informed by Mr. Lacombe that he did not have the authority over the accrual of vacation time, and Mr. Matson should proceed with talking with the HR. After not hearing back from Mrs. Balderas as to an acknowledgement of the email, on March 30th, Mr. Matson again sent an email on April 5th, 2022, but this time he sent an email to both Ms. Balderas and the city manager, Andy Okoro. The grievance accuses the City of Norco of not calculating Mr. Matson's vacation time according to the Memorandum of Standing, or the MOU. The MOU clearly states hours of service needed to accrue vacation time. Nowhere does it say the hours of service needs to be continuous. In an email response from Mr. Okoro on May 5th, 2022, he denied the grievance on 4 accounts. First, saying Mr. Matson failed to comply with the grievance procedure when in fact Mr. Okoro was the one who failed to follow the grievance process. Second, denying it on merit, stating that the MOU does not define hours of service. However, the MOU does define hours of service by listing what is needed to move from one step range to the next. Third, Mr. Okoro refers back to vacation accrual in the employee manual from 1991, which is an invalid reason. As the employee manual states, current MOUs cannot be disputed. This is also invalid since there is a current employee handbook from 1993. Are you guys aware of that, by chance?
As of now?
As of now, yes. I did a search on all manuals, and that's actually what it popped up. And so I will be submitting stuff from that. But there, I have the full copy with me, but I didn't print out a full copy for everyone because it saved paper. Since there is a current one in 1993, the only thing that it says, it also states that MOU supersedes the manual. It also states vacation is accrued in years of service without the stipulation of being continuous. So it states that the MOU supersedes anything, and it also lacks the word continuous when it comes to accrual of vacation. Fourth, Mr. Okoro states that past practice of calculating vacation occurs for employees and is based on continuous hours of service. However, to the knowledge of Local 606, there has not been any past employee who has ever come back and questioned vacation. So where is the past practice? As we proceed forward in this hearing today, I will provide evidence to support the facts that Mr. Matson is entitled to his vacation time being calculated on his accrued hours of service of over 10 years or over 10,000 hours of service. Thank you.
Thank you. What would be our next step, John?
Next opening statement from city side.
Yes, good morning.
Good morning.
Good morning, my name is Yesenia Carrillo. I am the attorney from Lieber Cassidy Whitmore, representing the city in response to Mr. Matson's grievance appeal here. The city manager denied Mr. Matson's appeal on the, the grievance on the grounds that the city has an existing, clear, unambiguous past practice of calculating an employee's accrual vacation based on continuous service. This is supported by the Personnel Rules Handbook from 1991. It also is consistent with the MOU. You heard that the MOU that currently is operational identifies vacation accruals on the grounds of hours of service. There is no definition in the MOU. There is also no definition anywhere else, and Mr. Matson will not be able to point to any evidence identifying a definition. So on those grounds, the city manager denied his grievance, and correctly so. The city is not disputing that Mr. Matson followed the grievance procedure that is outlined in the city's personnel rules. Initially, there was a dispute, but after further review, that is not going to be part of our argument here today. However, Mr. Matson did have 2 points of employment. He initially served employment with the city from 2001 to 2005. He was then rehired in 2016. Following the completion of his probationary period, consistent with the MOU, at some point he began to accrue vacation, consistent with the applicable MOU language. His grievance alleging that the city did not comply with the MOU and did not correctly calculate his vacation accruals did not occur until earlier this year, 2022. That is 6 years after he began his employment, his rehire date with the city. Based on his significant delay, there is no information at this point that we have that would justify why he was delayed in bringing his grievance. And so what I am asking is that on the grounds of a defense of laches, that the city council also deny his grievance, in that he was delayed in bringing his grievance since he began his employment in 2016. The defense of laches says that a grievant or a claimant typically cannot bring a claim when they are unreasonable in their timing. Furthermore, we will present, and you've received a copy of the exhibits. I will have one or two additional exhibits that further supports that the city's clear, unambiguous past practice of calculating employees' vacation accruals based on continuous service is consistent with the MOU and the personnel rules. There is also language in 2.32.190, employees' absence, compensable injuries, or disease, which identify when an employee has a break in service and they're going to continue to receive benefits, or their break in service is not going to count to interrupt any of their vacation accruals. Lastly, the city's personnel rules from 1991 also include a provision related to reinstatement, and I will be providing that provision to you as an exhibit, which makes clear that even when an employee in good standing leaves their employment, then is rehired within 1 year of their separation, they are not going to accrue any benefits until the conclusion of their probationary period and in compliance with any existing MOU. And so the evidence will show today that there is no language in the MOU and there is no other language anywhere that Mr. Matson can point to support his claim that the city violated the MOU when it calculated its vacation accruals based on his rehire date of 2016. Thank you.
Thank you.
Now the grievant can present their case in chief. This, by the way, just as a comment for everybody, this isn't a court proceeding, so the strict rules of evidence aren't followed, and we're gonna, and you're, I presume, essentially a layperson, and
Yeah,
so that.
so I don't know all the rules, no.
So it's gonna be somewhat more informal than it might be in some other setting.
So I've actually prepared folders for you guys so you can follow along with what I'm talking about, and I've highlighted.
Could you hand those to the clerk, please? Thank you. Can I ask a question, John?
Yep.
Are we able to ask questions, or is that not?
Yes, I mean, it's no different than, I mean, a judge can ask questions. You're essentially, that's what you are, but yes, you can ask questions.
Anytime or whatever, or?
Whatever makes sense. Wait until, I mean,
Sure.
it might make, I mean, if you have questions about, I don't understand what you're, then maybe during the presentation it makes sense. If it's something that it's just questions about additional facts that you want to ask, you can ask after the hearing.
Okay.
Okay. All right, so in Exhibit A, I put together as a grievance procedure. I know that they're not contesting it anymore, saying we didn't follow, but I just wanted to highlight some things, and I will just read through it. And then you guys can, I have attached the documents, the pages that you can find. Like I said, I didn't print out the whole manuals because that would waste a lot of paper, so I just printed out the pages that needed to be addressed. So Mr. O'Croll's first point was denying the grievance due to Mr. Matson not following the grievance process. So Mr. Matson's grievance cannot be denied because he did follow the process. Mr. Matson went to his superintendent, Derek Lacombe, and spoke with him about vacation accrual that was outlined in the MOU. Mr. Lacombe responded that this was an issue better suited for Cindy Balderas, the human resource manager. He sent the email on March 30th that we've already discussed, but she never responded to it. Then on the 5th, Mr. Matson sent another email to Ms. Balderas and the city manager, which then Ms. Balderas finally responded. I just wanted to take a quick note. If you got the staff report, you'll notice that the grievance was stamped April 4th. This second email didn't go out till April 5th. So she had it on March 30th, but chose not to respond until the second email had been sent out. On April 20th, Ms. Balderas sent an email stating she was working on the grievance. Mr. Matson responded with, "Thank you for the email. However, do you have an idea when you will have your response to the grievance?" Ms. Balderas never responded to that email. On May 5th, Mr. Okoro finally responded with 30 days after receiving the grievance, which is a violation of the grievance process. According to both employee manuals from 1991 and 1993, Step 3 states the city manager has 10 business days to review and respond. And then you said that you can't ask questions?
Pardon me?
They are not allowed to ask questions. I can't ask if they have any questions.
Yes, they,
Okay.
maybe you weren't listening.
I'm sorry, I wasn't.
Oh, okay, yes. Mr. Newton asked whether or not they could ask questions, and so they are aware that if they have the right, if they have questions to ask you, but they're not obligated to, but they have the right to.
Do you guys have any questions on that? Which I just
Go
asked?
ahead, Ted.
I just have one question. On line 3, and because it's not dated, Mr. Matson went to his superintendent, Derek Lacombe, spoke with him about the vacation accrual. Do you have the date that occurred?
It was sometime earlier in March, on the 30th. Before the 30th. He doesn't remember the exact date that he went to him.
So it was in March of
This year.
this year.
Yeah, and so to follow up with what was said in the opening, the reason why it's taken this long to get to this point is they just unionize. They went from an association to a union, and they went from having no one represent them reading through their material to having people represent them and read through the material. That's why it's being brought up now versus when he was first hired, because he wasn't part of the association. They had different presidents. This time he's part of the.
Okay,
Yeah,
I don't.
so
I just
I think-
needed. I wanted the date. That's all.
Okay.
So that was in March of this year.
Yes.
Okay, thank you.
And if we go to Exhibit B, which is merit, Mr. Okoro's second point denied the grievance on merit. He denied the grievance, saying the MOU does not have a definition of hours of service. The MOU does define the meaning of hours of service by listing the hours of service needed to move from one range to the next. So if you turn to the next page, it has page 9 of the MOU. You can clearly see that it has hours of service. You can clearly see that it says what hours of service you need to move to the next range. I mean, we don't need a definition that says an hour is 60 minutes. Service is your work. It clearly states up to 7,488 hours would be the first step. Once you go an hour past that, you will go to the next step. So what is there to define? What is there not to understand? It clearly shows you the hours of service needed to move from one step to the next. You guys have any question on that? And then if we go to Exhibit C, language from the Employee Manual, Handbook, and the Memorandum of Understanding. The grievance was denied using a accrual rate from Employee Manual from 1991. While the Employee Manual states vacation is accrued on continuous years of service, which is on page 28, it does, however, state on page 57 that the manual must keep, so I'm not paraphrasing, let me get it. It says, in reading this, the employee should keep in mind that the current memorandum of understanding may not be disputed, and there should be cognizant of those facts. Why did they use the word cognizant? Because you have to be aware. Because in this employee manual of 91, it also has benefits outside vacation. They have health, dental, life, vision. And if those facts, if this statement wasn't in there to say that you have to go from the MOU, well, then the city employees could come back and say, well, you know what? I want your health care benefits that are paid at 100% for the employee and dependents. This is specifically put in here so that current MOUs would dictate the benefits. Without this, we could have whatever benefit we wanted in the employee manual or in the employee handbook. This sentence is extremely important to realize that you have to go off of the current MOU when it comes to items that are negotiated. The grievance cannot be denied since the most current employee handbook from 1993 has in its first page, if you go to introduction of it, it also states, the goal of this handbook, first line, and then we'll jump down. It does not supersede, alter, in any way affect the municipal code, employment rules, regulations, or the memorandum of understanding between the city and any recognized employee organization or any other employee relation documents which have been officially adopted by the city council. The city council officially adopted the MOU with the language that it has. You cannot go back to this and decide that you want to pick from the employee manual because it's something that you choose. Also on page 13 of the new employee handbook from 1993, vacation accrual is explained as years of service. Without the use of the word continuous, meaning it does not need to be continuous. So you went from 1991 where the word continuous was in there, now it has been taken out. It changes the meaning. It does not need to be continuous. I was not there at that meeting when it was happening, but one can perceive that maybe it was negotiated on, maybe it was decided, hey, we're gonna take that out. But it was taken out, whether it was intentional, forgotten, or whatever, it was taken out. You can also go back to employee MOUs back to 1984, and none of them have the language continuous in the vacation. Which leads me to reason that maybe the word continuous was taken out in the 93 to represent the MOUs not having the stipulation of continuous. In the MOU on page 9, it explains hours of service with the use of the word, without the use of the word continuous. So if we go back to the MOU, it simply says full-time employees shall receive vacation accruals as follows. It does not say continuous. You cannot infer continuous. It is not there. You can only infer that full-time employees shall receive vacation accrual as follows. Once they've gone to 7,488 hours, their next step, they go up. It doesn't matter that it's not continuous. It does not state it has to be. You guys have any questions before I move to the next?
Go ahead, Ted.
In your program here, and just to, so you go Mr. Okoro's third point, you're talking about on page 28, that represents fire department. I'm asking you because that is, the fire department was a separate entity back then. So they had their own memorandum of understanding, their own contract. I guess I'm having a hard time seeing the relevance of putting that page in there when they were totally separate.
I agree. This is the evidence that the city is going to say is why it's continuous. This is why, sorry to just cut outside of this hearing, we have been asking for a new policy manual to be updated because these, both of them, even with the current one from 93, are very outdated. And they're misleading their information back and forth. It is just...
You can understand this. I'm trying to understand what your why you put this in here. And hang on. This doesn't even exist today because we no longer have a contract with the fire department. In reading this one page, what I'm reading is you're putting things through about the hours and continuous service. That was basically, if recollection recalls, this was for the fire department. No other bargaining group, nothing else. So I'm just having a hard time understanding why this is in there.
Because that's the evidence that the city has proposed why they have denied his grievance. So I'm just putting this page in so that you can see this is their evidence. And even though it says continuous, and even though it applies to the fire department, if we go to the last page of the MOU, it states, in reading this manual, the employee should keep in mind that current memorandums of understanding may not be disputed and therefore should be cognizant of those facts.
I'm not picking on your evidence. It's just,
Yeah,
you pick and choose on this. I mean, to find the pages that fit one person's narrative or another, it's hard to follow because this was specifically for a specific bargaining group versus the other page. It's just hard to follow
that was
without
the
the
evidence
okay,
provided by Andy to us.
So I just wanted to understand, this was specific to fire department.
Yes,
Okay,
it
thank
should
you.
have no bearing on the public works. Yeah, the employee manual, that page 28 was evidence that was submitted from the city. That wasn't from us. I am putting it in here to dispute it, is what I was doing, if that makes sense. I understand what you're saying, that it should have never even been in here because it is geared towards the fire department. I completely agree. But that was what the evidence was given to us of why they were disputing it. Does that make sense? Okay, I'm sorry. Anybody else have any other questions?
No.
Okay. So then Exhibit D, past practice. The grievance was denied, saying there was past practice of calculating employees' vacation accrual based on continuous hours of service. However, the local has asked the employees who have returned, have they ever been asked about vacation? Did they know that in the MOU that there was not, the word continuous was left out, and there was leading to the illusion that they could get their vacation accrual time back? Everyone that we talked to that returned said nobody had said anything to them. They did not understand the language in the MOU. They had no idea. So our question was, well, then where does this past practice come from? Because we are talking about the local. We're not talking about the whole city because we have our own MOU. So I'm talking about the local. When has this past practice been established? The only past practice that we can find is from the current handbook from 1993 where the language is being removed. So if we want to look at past practice, we can look at that where the language has been removed. And if you go back to Exhibit C, that's where you'll have the page from the handbook from 1993 where the language is removed and the word continuous has been taken out. Do you have any questions on that? Okay. Then we have Exhibit E, which is the Myers-Millis-Brown Act, which I have put together facts that need to be considered. Under the Myers-Millis-Brown Act, the MMBA, California Government Code Section 3500, the city is required to bargain with the union over matters that fall within the scope of representation. Public's Employment Relation Board, or PERB, has held that vacation benefits fall within the scope of the representation. The city cannot unilaterally change the vacation language in the MOU by adding a word without first bargaining with the union. This can be considered an unlawful unilateral change. The city has recognized that it has a duty to meet and confer, and that's illustrated in the MOU on page 4, Article 1, stating representatives of the City of Norco and the Public Works and Parks Maintenance Works Associates have met and conferred on salaries and benefits. We're not arguing the fact that you guys did bargain. The city and the local agree that they have met and conferred on these salaries and benefits. The city and the local did meet and bargain on the benefits of vacation. The city is legally bound to comply with the agreed upon provisions in the MOU. If the city wanted the accrual rate to be continuous, it was the city's burden to bargain that language in the MOU. The local does not have an interest in making the hours continuous, so the local would not propose the language. It would appear the city was unsuccessful, chose not to, or forgot to have the language changed to reflect the requirement of having the word continuous added to the language in the MOU. The city cannot assert the language is silent. Rather, the city must accept that the MOU simply does not require the accrual to be continuous. The city must accept the fact that both the employee manual handbooks from 1991 and 1993 both say the MOU supersedes them. That means the MOU is the current thing you have to go off of. You cannot go back to the employee handbook because you don't like the language in the MOU. That is something that is supposed to be negotiated on. It was negotiated on, and the language is as it is. The word continuous is not there. The city must also recognize, as it wants to look at the employee manual and handbook from 91 to 93, vacation benefits. For vacation benefits, then it will open the door for other benefits to be considered. If the city wants the local to use benefit language from the vacation manual and handbook, then the local wants to use the language for the health care as well, which states employee manuals and handbooks from 1991 and 93 that health care plans are paid at 100% for employees and dependents. So if we're going to take the language for vacation accrual from the employee handbooks, then we want the language for health care as well. If you go to the next page, I can let you guys read it. That is the law from MMBA, the Myers-Mills-Brown Act, stating that you guys have an obligation to bargain with us. We did bargain, and it also states the meet and confer in good faith, and that you have to meet and confer in matters of the scope of representation, which vacation is held up by PERB as in the scope of representation. Do you guys have any questions?
I have a question back on Exhibit D.
Okay.
Maybe I'm a little confused with this. This is in regard to Mr. Okoro's fourth point,
Yes.
denied due to past practice. When did Local 606 become?
They started to organize in February of 2001, or 21, sorry. It took some time because the city at first did not want to recognize the local. They fought it. We had to get an attorney to send a letter into the city for them to recognize them as the local. So the process started in February of 21. The exact date that they actually commenced I'm not exactly sure, about 6 or 8 months after that, before it was actually, the city actually recognized the local.
So your last statement, the question is, so where is the evidence that this is a past practice with Local 606? And maybe that's confusing me a little. So Local 606 has only been in existence for a year?
For a year, but they're the same people who are in the Public Works and Parks Maintenance Association. So even in that, so if we wanted to say that we wanted to go back to the beginning of the Public Parks Association, which was done in 2004, there still hasn't been evidence in that regard to a past practice. Local 606 is just the name of the union now. They went from being an employee-run association to being a local.
Okay.
With union representation.
Okay.
Does that make sense?
Somewhat.
Somewhat. Well, they went
I
from
don't know if it-
representing themselves to having a national union come in and help represent them because they felt they were not being heard.
All right. You have a question? Yeah, certainly. Go ahead.
In one of your previous comments about the hire date versus the grievance, I feel like you said it was because there wasn't representation, like there wasn't the union or the local for that. If I was an employee and my vacation wasn't being accrued, I don't think it would matter whether I was represented or not. I would go to HR and say, hey, like I'm not getting my sick leave, I'm not getting my vacation leave after a pay period or two. So can you explain to me why that didn't happen?
It would make sense, but when you leave it up to some men who don't even read the MOU, who still haven't read some of the
Well, no, I'm talking about, I'm talking about this specific case
Yeah.
at this specific time with Mr. Matson.
Yes. We did
Why
not
did that not
start
happen?
reviewing the MOU until they're in negotiations right now. So the process of starting negotiations and deciding what the union wants was to go back through and read their MOU. And starting back in March is when we sat down and started reading through the MOU, deciding what they want in it, what they don't want in it. And that's when it was brought to our attention that, hey, this isn't right. This, it's been in here, you're accruing vacation on this, but it's not saying continuous, and you should have a right from the time for hours served. Does that make sense?
Yeah, so it means when somebody signed their employment contract, they didn't read it until they joined the union, and so now we want to go back 5 years because we didn't read our contract when we originally signed it and potentially found a mistake?
Well, this, when Mr. Matson actually came back to Norco, this MOU was not in effect. So whether to say he read it, so there's nothing signed saying that he actually has read it and gone through it. There's nothing signed that says that they understand it. Just having a paper saying that, yeah, you've read it, does not necessarily mean you understand it either.
So whose obligation is it to explain a contract to an employee that signs one
I would
if they
think
don't
it'd be-
understand
In
it?
this case, my personal opinion would be HR, to make sure that the employee understands what what's expected of them. I mean, that's why you guys have the employee handbook, but you have one you're not even, was updated in '93 that you're not even using. You're not distributing. We have new employees that have just hired on in the last week down at the yard, and we asked them for the packet to see, because that was another problem, is the gentlemen in the yard over at Public Works are saying they never got the MOU when they first signed on. They never got these provisions given to them. So we have asked recently, with the new employees, because they've got,
If I may, I understand this is not a typical formal evidentiary hearing, but I would like to request that we stick to the point of today's grievance, which is dealing with Mr. Matson, and so it's really irrelevant any additional evidence or conversations that you've had with other employees. Thank you.
well, this is actually relevant to her question and relevant to the argument that he
No,
made
my
6
question
years.
was why, again,
Yeah.
this specific employee didn't read their contract and compare that to their accrual until 5 or 6 years later and then bring up the question. So it's specific to this one.
Just said he didn't know he was entitled to it. That's why we're here.
Entitled to reading
No.
your own
no,
contract?
He did. So you're asking if he understood.
Yeah,
the
so like, for example,
Oh, and I
I get 10 sick days a year. It's my responsibility when the new fiscal year starts to make sure that payroll and everybody put those 10 days or whatever it is there. And if they don't, then I call and I say, hey, you shorted me on my leave. Will you please fix it? That's within the first month or two of either the new contract or the new fiscal year. And so if I'm accruing sick leave, vacation leave, those things, I'm going to check my pay stub and make sure it matches. And then if it doesn't, I'm going to call HR or payroll or whatever responsible department. So I'm wondering why that, again, didn't happen within month 3 to 5. Instead, we're 5 years down the road.
Because it wasn't till the union, their national, got a hold of the MOU and started reading through the language and had asked. Since it doesn't say continuous, they had asked, what is your guys' vacation accrual? And we said, well, what is listed in there? And they pointed out the word continuous is not in there. It wasn't until that point that another person took a look at the MOU that pointed out the word continuous was not there.
Okay.
That's when we started doing research on it.
Okay.
Does that make more sense? It's like when
That's
you write a
an answer.
document, you'll pass it on to somebody else to proofread it.
Right.
You can read it. I can write up a document, and as in my head, it'll type out different. Because I was going through this morning. I already saw typo errors, but in my head it reads right.
Gotcha.
But it didn't come out right.
Okay, thank you.
Any other questions? All right, thank you.
Thank you.
Hello. They are passing around exhibits which are consistent with those that were submitted as well as those that have been brought up by Mr. Matson. I want to clarify a couple of things. First, the city manager's denial of Mr. Matson's grievance is based on a clear, unambiguous past practice. This means that there is no existing written policy in the personnel rules or in the MOU that define hours of service. So when we looked at Mr. Matson's grievance initially, we looked at his MOU. He cited that's what was violated. We looked at the Article 19 in the current MOU, which identifies hours of service, but it does not define it. Why do I make the distinction? Because Mr. Matson is asking that you all define hours of service to mean and include any point of employment that an employee has served with the city should be included when accruing vacation. That is simply not supported by the MOU. We then looked at the personnel rules from 1991, and it also does not define hours of service. We provided a copy of the provision that is included, which Mr. Hoffman correctly identified applies to the firefighters. We're not saying that that is the policy that applies to all employees. We provided that as an example and further support that the city's practice has been to calculate vacation accruals based on continuous service. I initially mentioned in my opening statement that there is also other provisions in the personnel rules, which you will get exhibits, and I apologize, I broke those up based on exhibits and didn't have them all together. But Exhibit E, which, and I think you should be getting that. Talks about reinstatement. It states that a full-time regular employee who terminates his or her employment in good standing may be reinstated to a vacant position in his or her former job class within 1 year. So when we're looking at employees who return after separating their employment with the city, the only time that the city will reinstate, and so potentially their hire date continues, is going to be if they satisfy this reinstatement provision. However, this provision also states that the employee is not going to accrue new benefits. They're going to accrue based on whatever existing policy exists, whatever MOU applies, and they also must serve a probationary period. Mr. Matson was initially employed from 2001 to 2005. That was his first period of employment. He was part of an association. There was discussion about association and a union. There was an effective MOU in 2004, and each of those MOUs includes the same language, hours of service. It does not define, it does not include continuous service. Again, this is because the city's practice has been historically to calculate that vacation accrual based on continuous service. And again, we point to the provision in the 1991 as a further example, not necessarily to say that that is what applies to these employees, because that applied to the firefighters. I want to go back and point to the MOU language, because
A question?
yes.
I'm going to assume it's for you, that, so from 2001 to 2005,
Correct.
Mr. Matson worked for the city, left in good standing, so it was a clean separation. Is it safe to assume that Mr. Matson was paid out all his accrued sick leave, vacation leave, whatever was due him?
Yes, that would have been in compliance with the law.
Okay.
So that would be safe to assume. But once I present the exhibits, I will ask city manager to join us, and we can ask him questions to verify if he
Okay.
has that information.
Thanks.
And that would be consistent with the law. California law does require that if an employee is separated, whether it's voluntary or involuntary, that they receive a payout for his vacation accruals. And so I would represent that the city complied with the law and would have paid out. And we don't have any information. Mr. Matson's grievance doesn't allege that there wasn't a payout. He is simply asking that we count the 2001 and 2005 period of service in order to calculate the hours of service, which is clearly not supported by the MOU, by any of the existing MOUs. And I also want to point out another provision in the MOU that further supports our position. Exhibit A, which is Mr. Matson's grievance. The second page of his grievance, the very top, there's an identification of a number 1 and a number 2. The number 2 states, employees will cease to accrue vacation hours when in any period they exceed their annual accrual as determined by their anniversary date. If we are to interpret that hours of service is based on his first hire date of 2001, then it would assume that that the 2016 is not relevant for calculating anniversary date, and that just would be inconsistent with the interpretation of the MOU. There's really no grounds to support that the anniversary date doesn't start again when he is rehired, which is the 2016 rehire date. That's also consistent with all of his employee records, which show that he was rehired in 2016. Mr. Matson argues and asks that this board read into the MOU that hours of service means all hours. Again, that simply is not supported by any of the language. And he does have a responsibility to be familiar with the MOU. There has been an MOU in place, and I did review the previous MOUs, which again included that same provision. And so there is really no evidence in the justification that because now they are part of a larger union, Local 606, that's why that he is now bringing his grievance. Is just not supported and it is not reasonable in calculating. 6 years have passed. Whether you didn't understand what the hours of service meant, what the MOU meant, there would have at least been an inquiry to understand and know why you're being paid you're accruing hours based on your 2016 rehire date versus the 2001. And so the only logical and reasonable conclusion is that he understood that he was rehiring and his employment with the city was starting again and would not include any of the period of his employment from 2001 to 2005. Again, during my opening statement, I mentioned that there is an ordinance. I did not provide a copy to you, but we can provide that as well. And that is 2.32.190, which talks about when a break in service is not going to be a break in service. And so, again, there is no other provision in the personnel rules, in the ordinance, or in any of the applicable MOUs that apply to Mr. Matson that supports that he would be entitled to count his first period of employment in order to calculate accruals. Mr. Matson argues that we can't pick and choose. We are not picking and choosing. We do not dispute that the MOU supersedes the personnel rules. But that means that it supersedes any existing and negotiated provisions. If there is nothing in the MOU, the personnel rules would control. When there is nothing in the personnel rules, we look at past practice. That means, what has the city historically done? We don't go and interview employees. We talk to our administrators, our city manager, our human resources, and we ask, what has been done in the past. The practice of the city has been to calculate accruals based on continuous service. And again, the provision that was provided to you is an example that has been consistent with the city's practice, and to some extent there's a reference to it from 1991.
I have a question.
Yes.
Sorry, I'm over here. So they made mention of a 1993 MOU that we were asked if we knew it existed. Is it 1993? Is there a reason to discount the 1991 MOU? And then, was there anything to the idea that you could simply pick and choose what you wanted? I was a little bit confused by her statement that she could just pick or choose. But should we be looking at the 1993, or does one supersede the other? Because you're referencing the 1991.
So I want to clarify, her reference to the 1991 and 1993 is to the city's personnel rules and not an MOU. I am not familiar with the 1993 personnel rules. The copy that I received and that I've been working off of is the 1991. But even without reviewing, based on the testimony provided on behalf of Mr. Matson, there's no inconsistency. The only difference has been that the 1993 personnel rules identify hours of service. Again, there is no definition that Mr. Matson cites to in the personnel rules. And so to address your second question as picking and choosing, we're not picking and choosing. When we receive the grievance, right.
Statement was employees, given the way the MOU, the employee rules, guidelines were written, they could basically pick and choose what benefits they wanted.
And that's not correct. So, right, that is not correct. I disagree with the representation that was made. The employees do not have the ability to pick and choose. Again, when an employee is part of a unionized group or is represented is really a better term, because that may be by an association, which they were initially, and then by a much larger recognized union, the MOU is going to control. But if there is nothing in the MOU, we look at the personnel rules.
All right.
If there is nothing in the personnel rules, we look at what has been the past practice of the city. And that's really the order. There's no violation. We're not picking and choosing. Employees can't come back and say, we want the vacation accruals of the firefighters. We're not trying to enforce any of those provisions. Again, that was provided as an example to demonstrate the consistency and further support the past practice that exists. And so consistent with the MOU provision, the employees are going to accrue vacation based on the hours of service, but that hours of service is based on their anniversary date, their date of hire. Here we have two dates of hire. We have one in 2001, which then concluded in 2005. We have a rehire date, not a reinstatement, a rehire date of 2016. That starts a new anniversary date, and that is the date that is being used to calculate the vacation accruals. Does that answer your question?
Did I understand correctly? When the gentleman left the first time, everything was closed out. In other words, he got his accruals, all those kind of things. That's my understanding? So basically it was fine, he was finished.
That is my understanding, but if there's no objection, I'd like to ask Mr. Matson if he disputes that. You do not? Okay. He's shaking his head, so he doesn't dispute. So the representation is that he was paid out any accruals that he had at that time that he would have been entitled to a payout with respect to vacation.
So it was cut, he was done.
Correct.
Then my second question is, and forgive me, I can only reference this to my own union. It's funny, I just told this story yesterday. I tripped over a cord, and I put the cord back in, plugged it in, and I was fined by my union. And when I went to them and I said, why? They said, you didn't read your handbook. You're not allowed to touch anything electrical backstage. So I lost a week's salary. Is that, are we looking at the same situation where we are responsible? Or does that have to say that in the employee handbook? Or does it have to say that somewhere that you must read or understand your conditions of employment?
Yes, that's generally an expectation. I would venture to guess, because the personnel rules, whether you look at the 91 or the 93, I can't talk about the 93 because I have not reviewed them, may not have those provisions because they're much older handbooks. But typically that is common. I typically review and see handbooks, and when I prepare them, I include provisions that say the employee has a responsibility. We typically issue acknowledgements in which the employee acknowledges that they've received a copy. We can't force an employee to read their personnel rules or the MOU, but we can expect that we're going to be enforcing them. Whether
Piggybacking off of what Councilwoman Grunmeyer said, that, you know, there's an expectation you're going to, I mean, I don't know if we do this here, but I used to have to sign it. Anyway, I was just curious if that's how cut and dried this was. Thank you very much. I apologize again, Council, for my remoteness out here. Thank you.
So I do have a question then. Do the employees have to sign that they have received a copy?
of the personnel rules,
Mm-hmm.
I'm going to invite our city manager to answer that question.
I am not sure about that, the answer to that question. When an employee is brought on board, they do go through a check-in with HR, and all the documents that they sign and acknowledge receipt would be in their personal files. With respect to this item, I don't know that they actually sign that they have received a copy of the personnel manual. However, we do have MOUs, as you know, that is entered into between the city and employee associations, and the leaders of the association do represent the employees that are covered under that. It's clearly up to them to make sure that everything that is negotiated as part of that MOU is explained to the members of their association, and that each member of the association is very aware and very knowledgeable in terms of what has been negotiated between the association and the city, in particular with those issues that impact compensation, hours of employment, and benefits.
Mr. Okoro, since we do have you on the mic, I would just like to ask you some questions consistent with the exhibits that we've reviewed and my personal opening statement. Can you please tell the committee whether you reviewed the initial grievance that was received and how you arrived to your denial of the grievance?
Sure, I did receive the grievance that was filed by Mr. Matson after it was submitted to the Human Resources Department. In deciding whether the grievance has merit or not, I looked at the provisions in the MOU. I looked at the provisions in the personnel manual, and clearly the MOU did not reflect that definition with respect to continuous service. So my fallback was on the provisions that are in the personnel manual. But it's pretty actually logical that if you look at the graduated nature of the accrual rates, is designed to reward employees based on continuous years of service. That is why the accrual rates are graduated. And once you leave city employment, the intent is not to reward you if for so many reasons you come back and gain employment with the city that we go back and count those out, those years that you provided services to the city.
Thank you.
Was there, with that, wasn't there like a one year stipulation? Like if I left and 6 months later go, you know, I want to come back.
Correct.
If I'm within a year?
The city's personnel rules do talk about reinstatement within the
Yeah.
1 year, but again, it says that it's without benefits. And
Okay.
so they're going to accrue benefits based on if they're going to be covered or subject to an MOU, and if they're not, then based on the personnel rules after they serve a probationary period.
To note that the reinstatement we're talking about is an employee who's left in good standing, and within 1 year, if that position currently exists and is reinstated to that position, the personnel, this rule doesn't allow for accrual of benefits to be retroactive to the time of reinstatement. In Mr. Matson's case, the situation is much further removed, that he wasn't even actually reinstated. He came back and through a separate employment process had to compete for a position and was hired into that position. So clearly he was hired as a brand new employee who started to accrue hours based on that anniversary date that has been mentioned.
Are there any other questions? That concludes.
I have a comment and a question. Just, you know, as the council, we're still treated as employees of the city. And most recently, when I was elected, I received a binder that was this thick that had all the information I had to sign. You know, usually in most of, you know, any employment, when you're hired, you receive everything. And then anything else that's not in there, like a contract, if you're in a union, is available through your union or on their website. So just to speak to that. And then second, this is, you know, looking at years of service, it's a common practice, correct me if I'm wrong, across, you know, all industries. It's seen as, to what our city manager said, as a benefit, right, for employees who stay in the organization rather than leaving. And so it's interpreted, regardless of where you are, by your hire date. And if there are multiple hire dates, it's the most recent hire date. Correct, right? This is standard
Correct.
across. And the second thing would be, you know, if somebody did leave and came back, that would be something that they could negotiate, perhaps, or ask for at the time of the hire. Sometimes there are allowances that are made for that, but that is not done many years after the fact. It was something that would need to be asked for and granted or not when a person is hired, correct?
Correct. If I may just clarify though, here we're dealing with an employee who would be a member of the union.
In which
And
case
so,
that's not
so
applicable.
typically it would not be common practice in my legal experience for there to be a negotiated term to provide them accrual
Because
rates.
the contract is the negotiated term.
And now we're inconsistent with the MOU of providing an additional benefit that is not provided to all the other employees who are subject to the MOU.
Thank you for that clarification.
Okay, I'm gonna try to keep this narrowly focused. Mr. Matson worked for us from 2001, 2005.
Correct.
Paid out, left in 2005, was paid all his accruals, as he said. So
Correct.
we're done there with that. He comes back 2016, 9 years later.
Correct.
And let's, I'm just trying to get the state of mind here of the hire date. What?
11 years.
11 years, okay.
Right. Yeah. Sorry
Math
about
is-
that.
Okay, thank you. So we got 11 years. The time of his rehire, was there anybody, any implication or anything implied, anything stated by any of our staff members or our employees of the hiring that these hours would be contiguous or that we would go back in there, to your knowledge?
Based on Mr. Matson's grievance, that doesn't appear to be the case. So he's not arguing that that occurred. I don't have personal knowledge. This is where his delay of 6 years from his rehire date of 2016 presents a potential issue. I believe the city's human resources manager was not employed during the 2016, so we would need to determine whether if there's anyone within the organization who was HR or in a position to have those conversations with them.
I'm just trying to focus this on here.
So based on to
So-
answer your question, based on my knowledge, there's no information and there's no evidence being presented that there was ever a conversation by the city stating that he would receive that he would receive credit for his initial employment for purposes of calculating vacation accruals.
Okay, I'm just trying to narrow this down.
Mhm.
And then you're next.
I can
Okay.
answer the question. For me, I interviewed Mr. Matson at that time, ultimately hired and met with Mr. Matson. That particular conversation regarding anything about vacation, past accruals or whatnot did not occur between us.
Okay, so there was no implied, no question, no answer, nothing. That's just trying to get this focused because that seems right. And the union didn't start, that we have the 606 didn't start until 2021.
Correct, but there was an MOU.
Correct, and that's what I'm just.
Okay,
you know,
yes.
So we have the MOU that's been in existence for these employees prior to that we have worked on during negotiations over these past years.
Correct.
That thing. So but there was no major changes other than that, and the first knowledge that we have of this questioning of the contiguous has only been done recently, after almost 6 years after the date of his rehire. Correct?
Mm-hmm.
Yeah,
Correct.
I'm just getting the facts. That's
Correct.
it. Thank you.
I have a question.
Yes.
Right before February 2016, this was an advertised position? And assume we had multiple applications and multiple interviews? Okay. Thank you.
Any other questions? Thank you very much.
Thank you.
Mr. Mayor, part of that advertisement would have also been the benefits, the compensation, the vacation accrual rates, and all of that would have been part of that job flyer.
Thank you.
Okay, now.
John?
Now we have 10 minutes each for closing arguments, beginning with the grievance.
Okay, so we can all agree, and the city agrees, that the MOU does supersede, correct? Andy, Mr. Okoro, you agree the MOU
Yeah, this is-
supersedes?
With recognizing that this isn't a court
Okay.
process, it's your opportunity to make a formal
Okay.
closing argument to them.
Okay, so earlier, everybody agreed that the MOU supersedes the employee handbooks. If we look back at the employee handbook from '93, the language is taken out of continuous. The one from '91 we have recognized has also been stated for the fire department. It did not state for the general employees. Okay. Regardless of what any of the manuals say, though, the MOU supersedes them both, and both of them have clear language stating the MOU supersedes. The MOU is a bargaining tool that is done between the city and an organization, a union, to discuss benefits and how they want their benefits outlined. They have a contract set up. It has dates, beginning and ending. It's a meeting of the minds, and they negotiate on all their benefits, from vacation to sick leave, to health care, to dental, to vision. Everything is negotiated on. This MOU was negotiated on. The MOU does not say it has to be continuous. The fact that you want to go back to an employee manual to say, well, there's not the language because the word continuous isn't in there, so I'm going to go find it somewhere else, cannot be used, because this is a document that is negotiated under the MMBA rules. It is a provision. They are allowed to negotiate on vacation. So if we are going to go back and say, nope, we don't like it because it's missing this word, then what's the purpose of negotiating? What's the purpose of them negotiating on their benefits? So you're saying that in negotiations right now, they couldn't go and say, we want it to be not to be continuous. That is a right that they have to negotiate. It is the right of the city to have negotiated that language in the MOU. The city did not negotiate the language to say continuous. You cannot infer that it has to be continuous by looking at a manual that one says continuous and the current one says it's not. You have to go off of what the MOU says, what the bargaining units bargained for. If I were to come to you and say, I want 100% health care paid, the handbook says I can have it, but my MOU says it's $12.50. You're going to tell me, no, the MOU says $12.50. I can't tell you, well, the handbook says it's 100%. You're going to tell me the MOU supersedes the handbook. So why are we not saying the MOU supersedes it when it comes to vacation as well? It's a part of language that was mistakenly probably left out. That is not the union's fault for that language to be not in there. It's something they're not going to bargain for, because why would they give up a benefit? That is a loss of a benefit to an employee. So why would they bargain for it to be taken away? They didn't. It's not in there, meaning in the MOU, the time of vacation is continuous. The MOU was negotiated in accordance with the MMBA. It was done with the rules that are established for negotiations. PERBS has held that vacation benefits fall within the scope of representation, which means in the MOU, vacation is a bargaining chip. You can bargain for more vacation. You can bargain for less vacation if you want to say, I'll take less vacation, but I want more pay. It is something you can bargain with. You can bargain to have it start when you want it to start, when you don't want it to start. It is all up to bargaining. The city and the local did bargain over vacation. It is outlined in the MOU. They met and they conferred and they did bargain over it. And it is a legally binding MOU. Means you have to go by the provisions in the MOU. You cannot unilaterally change the language because it doesn't fit you. You cannot say, well, I don't understand it because it doesn't say continuous. What is there not to understand? It says it accrues as hours of service. It doesn't need to have the word continuous in it for it to have meaning. The city was unsuccessful, chose not to, or forgot to add the word continuous. It does not mean the language is silent. Because the word's not there, it doesn't mean I have to pretend it's there. It's not there. The MOU simply does not require accrual rate to be continuous. And as far as past practice, there's still no evidence. There's still no evidence of anybody being denied having their accrual vacation start over. They say past practice, but now we have this question of a manual in 93 that says it accrues on years of service and hours. It does not say continuous. So past practice would then state and be consistent with the MOU that continuous is not a requirement. And again, vacation is a bargaining unit. It is not something that's mandatory that you have to give to employees. It is not something that has to be given to them, so therefore it is a bargaining unit. We can add to it, we can take from it, we can change it around. It is something that needs to be bargained for, and that's what the purpose of the MOU is. Now we have the question of whether Luke or Mr. Matson read the MOU and whether he understood the MOU. Well, I was sitting up here listening as the council over here explained the MOU to you guys. So if she has to explain it to you, why would we assume that he understands the language of it word for word? Why is it that he has to understand it, but nobody else has, that somebody else can have counsel of understanding for it? And that's exactly what happened. We started the bargaining back in March, reviewing the policies, the MOUs, and that's when it was discovered that the word continuous was not in there, which led to a different meaning of vacation. The vacation accrual is continuous, or not continuous. It has to be hours of service. The vacation is done for hours of service. It does not say continuous. And that is something that was bargained for in the MOU. And we can't dispute that we bargained for the MOU. It is written that they negotiated, they met and conferred. It was signed off by the city manager and the council. It is acknowledged that it was bargained for. So we cannot refer to something else and say, nope, we're not going to take it now. It was bargained for. Maybe it's something that needs to change in the upcoming negotiations, but at this point, it is not in there. And we had the topic of continuous service is something of an award. Well, if we go to the MOU page 7, there is a provision for continuous service. It talks about continuous service bonuses. For 5 years of anniversary, you get $100, 10 years, $300, 15, 500, and so on. That, in this exact same MOU, has the word continuous in it, meaning to get this bonus, you had to be here continuously. But when it comes to vacation, on the next page over, on page 9, the word continuous is left out, which means it does not have to be continuous. It's just hours of service. So if we want to look at understanding the language, we can see it in the MOU. The MOU shows when it wants to be continuous, and it shows when it does not need to be continuous. And just once again, the MOU is a tool for bargaining with the city and its public employees on hours, wages, and working conditions. Vacation is in the scope of this, as well as healthcare, dental, and everything else. It is something that was bargained for. It was something that was agreed on by the city manager and the city council at the time. The language is as it is. The accrual of vacation is hours of service. It does not say continuous. Therefore, you cannot think of it as being continuous. Thank you.
Thank you.
Mr. Matson has the burden of proof of demonstrating that the city violated the MOU in calculating his accrual rate based on his rehire date of 2016. And that should have been calculated, as he claims, based on his hire date of 2001. He has failed to meet that burden. The city does not dispute that the MOU is controlling. As we stated in our evidence, as the city manager stated, we reviewed the MOU first. The MOU uses the phrase hours of service. It does not define hours of service. To Mr. Matson's point, it doesn't say one way or other whether it is continuous. This is why we then look at the personnel rules. Again, the personnel rules are silent, which is then why we look at the past practice. And consistent with the city's past practice, which is further supported by the personnel rules dated 1991, it is clear that an employee's vacation accruals are calculated based on continuous service. There was a reference to the bonus. That is a separate benefit that is provided and is not related to the accrual of vacation. Further, the MOU also includes that the hours of service and the accrual rates are based on an anniversary date. If we are going to agree that Mr. Matson's point is true, that means this committee will have to determine that Mr. Matson's anniversary date is a 2001 date, which may have significant implications to any other benefits, which has the potential of being contrary to other provisions in the MOU. We take the position, the city does, that there is no existing written policy that defines that whether the vacation accruals or hours of service is based on considering a break in service or continuous. This is why we look at traditionally what has the city done. The past practice, which is clear, unambiguous, has been to calculate an employee's vacation accruals based on continuous service. Lastly, as I initially stated, Mr. Matson has been significantly delayed in bringing this grievance. It's been more than 6 years since he was rehired in 2016. There was an effective MOU in place. The personnel rules have been in place, and this is the first that we hear that there is an issue with the grievance. And therefore, he should not be able to take advantage of that, of waiting the 6 years before bringing this forward if he truly believed that hours of service should be interpreted and was meant to be interpreted and defined to include any break in service, which is not reasonable. For this reason, the city requests that you uphold the city manager's denial of the grievance, that you make a finding that the city's past practice is consistent with the MOU and the personnel rules, which is to calculate an employee's vacation accruals based on their date of hire and based on continuous service, and does not take into consideration any prior hire dates, as is consistent with the personnel rules that talks about reinstatement, which highlights that benefits are not going to continue based on any previous hire date, even when there is a reinstatement. There is nothing in the MOU that talks about accounting for any prior service, and it's simply not logical to find that the accrual rate should be calculated to take into consideration all of an employee's employment with the city versus their rehire date, which in certain situations may be significant. Well, we only have Mr. Matson's grievance before us. If the city finds, if this committee finds that in fact hours of service includes all periods of employment, we can expect that there will be other grievances, and we will need to determine whether there are any other employees who had any previous hire dates for consideration. And so the decision would impact not just Mr. Matson, but also the city's practice.
One question that I have that it's just a factual question, because we've talked about past practice. How many, if you have any idea, employees have been rehired after a break in service? Because that's the only time this is an issue. I mean, that means that an employee in this unit left, break in service, came back again as a new employee. Has that occurred frequently, ever?
I don't recall a specific situation with respect to this bargaining unit.
Yeah. I mean, in which case,
Any
two?
chart? Two. Okay.
Yeah, but he came back in a different position. He left as a maintenance worker 3 and came back as a supervisor, or was promoted?
He left as a position he wasn't. He left.
Oh, okay. I mean, okay, but it's essentially the same as when he left. Okay.
There is an example, second person.
On that same note, would that only affect employees that are in an association or a union, or would that affect management or mid-management?
It only, as it pertains to this grievance, it only affects those who are subject to the MOU.
That practice is traditionally applied to every employee.
Yeah, I mean, the issue may come up in some other circumstance, but this grievance pertains to this
We have
MOU.
had a situation where an employee in mid-management left, came back, joined the city in a different management capacity, and the same practice was applied, which means the accrual rate starts from the beginning, the date of the rehire.
I have one last question, if I may. It was mentioned by previously that little spiff that we give to employees, you know, here's $100 for being here 5 years, 10 years, or whatever that is. Would that have to be addressed in an MOU? That I look at that as we just kind of out of the goodness of our heart. Thanks for being a good employee. You've been here a long time. Here's your $100 in your little lapel thing, right? If the MOU or general employees agreement, whatever we have, if it doesn't address that, would be appropriate to still give that?
So I want to clarify that Mr. Matson was claiming that the MOU includes a provision, which means that the parties negotiated that provision to provide that bonus for continuous service. I would need to go back and review the personnel rules to see whether there's any equivalent provision, and I'm not aware of any practice, but it wasn't part of my review in reviewing this grievance, so I can't answer one way or another. So
That's it. The simple answer that isn't directly related to this case is that any benefit like that is bargainable and should be reflected in whatever the MOU is. It is in the MOU.
correct.
Okay.
That's a provision
Okay.
in the MOU
Okay.
that
All
she
right.
was citing to.
Yep.
Or apologize, that Mr. Matson was citing to.
Thank
So
you.
the city would not have the ability to say, no employee, we're not going to give you that bonus if they meet the provisions that are included in the MOU.
Or that we're going to give you more.
Correct.
So question. Where do we start that one, Andy? At like 5 years? That little thing we do once a year. I call it a spiff, so.
I think it's 5, yeah.
Five years. So I guess my question then would be for Mr. Matson, if he came back in 2016, did he get one in 21? For being here 5 years. Okay.
Oh, no, to answer your question, a year after I'd been back, had you give it to me?
Did not.
Did not.
Okay.
Well, and I just want to clarify if he received it on his, I don't have the provision in front of me, but today's grievance is specifically related to the accrual rate for vacation.
Correct. Right.
And
If we're off
if-
topic. I
And
don't.
if he received it the 6th year,
Actually not.
it may be that we need to look at the language of the provision, which I'm scrambling to find, which means that he may qualify once he's completed his 5th year, and you may have then provided it the 6th year. So I want to just make sure that we clarify he claims he received it the 6th year. We would need to look at that language to determine whether that's consistent with that provision.
Okay, then.
Okay.
Thank you.
Thank you all for your time. Is somebody going to bring Kevin?